Okay, you're welcome to go ahead and start the meeting.
Thank you, Tessie. Morning, everybody. Welcome to the October 14th Sexual Misconduct Committee meeting. We have the following members present. Mr. Ganadakis.
Present.
Mr. Jackalone.
Here.
Ms. Montgomery. Ms. Montgomery, there you go. Ms. Montgomery's present. Thank you. And myself, Michael Schottenstein. Could I please get a motion to approve the September 9th, 2020 committee meeting minutes, please?
So moved. Second.
Mr. Jackalone. And forgive me, who was the second?
Jackalone.
Thank you so much. All in favor? Aye.
Aye.
Thank you all. So maybe we can move to a discussion of proposed legislative matters. Kim or Nate, if you'd be so kind.
Yes, thank you, Dr. Schottenstein. I'm very excited to be with you this morning talking about this. This is the culmination of many months of just a lot of collaboration among staff to come up with what we think are some good recommended changes and some good draft legislation that responds to the recommendations of the Strauss Working Group, and also finds some additional areas that we feel will enhance the board's ability to be responsive to indictments' ability to discipline sexual misconduct. So with that, as you all recall, in July, you had seen a draft proposal of many of the statutes. I think we talked about them sort of separate and apart from the F5, and then subsequently we had additional discussions in August and September about the F5 provisions. This draft incorporates all of that together in one legislative package. After our meeting in July, we took the comments from the board and incorporated them, and also sent the draft legislative proposals out for comment to outside groups. In your packet, I have provided you a spreadsheet with comments from the outside groups, as well as the individual comments themselves. So we are very pleased to get the level of detail of comment from various groups, particularly the Ohio Prosecuting Attorneys Association, an individual, Kelly Heil from the Butler County Prosecutor's Office, as well as other comments from our more typical stakeholders like OSMA and OHA. So with that, we took all of these comments, had some additional discussions internally with staff. We drew upon the great experience that our Deputy Director of Investigation, Compliance, and Enforcement, Angie Canepa, has related to some of the criminal statutes, and really, I believe, have come up with some recommended changes that really are responsive and lead us to where we want to go. With that, Dr. Schottenstein, I ask your permission to give a high-level overview first, and then go back and get into some of the bigger changes in more granular detail. I particularly want to note to you, okay, thank you. I particularly want to note to you, there are some brand new items that you have never seen, but I do not, some of the new items are not particularly controversial, and others of them are I believe, probably issues you will want to discuss in greater detail. So with that, going off the memo is divided into 4 sections. I'll start off with the statutes on criminal conduct. This is basically one of the things that was discussed at the July 8th board meeting was, are we covering enough of our licensees? Do we need to add and go past just having doctors and PAs on it? So basically the recommended change is to add massage therapists, and that change is database based on data we pulled from Salesforce on the total number of complaints that we've had for the last, I believe, 26 years. So we took the licensees with the most complaints and decided that the addition of massage therapists would be appropriate. So with that led us to actually putting a definition into 2901.01 where we talk about a licensed medical professional, which enables us to draft a lot easier in the other sections where we're referring to a licensed medical professional instead of a doctor of osteopathic medicine, a doctor of podiatric medicine, et cetera, et cetera. So we've listed out the PAs, the physicians, all three types, including those who are holding training certificates, and massage therapists. Secondly, we received several comments, or at least 2 comments from prosecutors that indicated concerns that that the sexual contact part of the legislative package, and that would be defined as the touching of the erogenous zone of another, so not sexual intercourse, but the type of conduct that many of the news reports regarding Dr. Strauss talk about with, touching, a student athlete's penis, that sort of thing. Many of these comments talked about how criminalizing that as just misdemeanor sexual imposition conduct was inadequate, and particularly involving victims that are minors, people under the age of 18. This was particularly inadequate. And so the recommended change is to change from criminalizing or to criminalize sexual contact as a felony sexual battery instead of a misdemeanor sexual imposition. It would be criminalized as a felony sexual battery, felony of the 5th degree. If it is a minor, it would be a felony of the 4th degree. This would be less than the sexual conduct, which would be a felony of the 3rd degree, and then if it was a minor, a felony of the 2nd degree. So I will go back and discuss that in additional detail, but based on the comments of the prosecutors and the way that it fit into the criminal statutory structure, we feel that this is a good recommendation to consider. If the board would decide to make that change, that would mean that we would no longer need the sexual imposition section 2907.06 in the statutory package. In addition, we received some comments regarding the need to define medical treatment. Some of comments from internally and externally thought that exam and procedure may be adding massage therapists to it. So we drew upon the definition of, and did not take that rule whole cloth, but rather incorporated that it must be obviously in person, and use that to define medical treatment in 2907.03 C5 in the definition section. So that clearly puts everyone on notice what is covered under this relationship-based offense. The second part of the memo talks about prosecutor notification of indictment/conviction or court notification of conviction. In the course of looking at these, we discovered that there are statutes on the books that mental health professionals who have a similar type of relationship offense that we are striving to amend into the sexual battery section, they are required by RC 2907.17 to be notified by the prosecutor when a mental health professional is indicted for sexual battery or sexual imposition. And in addition, in 2907.18, the court is required to send notification and documentation of a conviction of a mental health professional for those offenses. So we believe that it would be entirely appropriate to recommend to amend the statute to include the one is convicted for a whole host of offenses. It's a very long list of offenses. And the recommendation is merely to update the statute to account for all of the medical board's licensees. Doctors and PAs are accounted for, but I believe the statute just hasn't been updated to account for such providers as dietitians and respiratory care professionals. So 4759, 60, 61, 62, 74, and 78. And so this would just make sure that we were getting comprehensive notification from the prosecutors. Other people that are covered in here, I believe, are nurses and the pharmacy board. So it would just make sure that we were getting the notification for all of our licensees. These three statutes, I again want to note to you, are brand new. You have not seen them again. I don't believe they're highly controversial, but I do believe that they will aid us in being able to get prompt notification of when someone's been indicted or when someone's been convicted, and then we can really act, particularly the first two statutes regarding the notification of a sexual battery. If it's a conviction, will enable us to access our ability to immediately suspend someone under 4731.22I, automatically suspend someone. And then in addition, if the board, if we approve this legislative package, our section in 4731.22P, where we're doing an emergency suspension based on an indictment, these will also dovetail nicely with that as well. Thirdly, the reporting statute. Ms. Montgomery?
I'm sorry, Ms. Montgomery, you're still muted.
Did you want to just wait and have questions afterwards? After he's presented.
If that would be okay with you, that would
Okay.
What I was hoping for.
That's just a lot of information to get through. If are you almost done? Because there's a lot of information that you're trying to have us digest and then respond to.
If there's something you really like to ask right now, feel free.
No,
Okay.
that's all right.
Thirdly, on the reporting statutes, many of our comments really were asking for clarification around some of the language. So we defined key third party in the 2921.22. There was some discussion on several comments about there was some confusion regarding the exception language in F2. So we added a timeliness requirement that the report should be made within 7 days of obtaining the knowledge or belief, and that around the exception report, clarifying that language to talk about with the exception of a self-report or participation in the violation of law being reported. And there's some other just clarifying language. In addition, as to peer review, there was comments regarding that we needed to clarify that the subpoena we're talking about is an investigative subpoena rather than a subpoena from the Chapter 119 hearing process. As to the 4731.224 reporting misconduct, we clarified some language around in Division G that made sure that when we're getting reports of sexual misconduct or criminal misconduct, these reports are reports that traditionally open a complaint, that these reports would not be subject to the disclosure to the licensee. This is just cleaning that up, so we're not compromising a medical board investigation when where we would immediately notify the licensee. That would compromise the investigation. There's some additional changes in that are really for either consistency or clarity. And then in the last section, disciplinary and patient notification statutes, we've made some minor changes in F3, just clarifying the subpoena language. And then in Section P, Section P is basically that previous section that we've talked about, a new proposal to do an emergency suspension based on an indictment. So there's just been some clarification of that language in Section P. And then we have also incorporated all of the F5 changes that were previously agreed to. And then in 4731.99, we recommend differentiating the penalties for failure to report sexual misconduct and or criminal misconduct from the other failure to reports in 4731.224 to I think make them consistent with 2921.22, the misdemeanor of the fourth degree, and also to give them the differentiation that the conduct itself deserves. In addition, we added that penalty provision that had been previously agreed upon by the committee, criminalizing disclosure of F5 material. That's included in that as well. And then the last thing, and I will quit filibustering here, is that we have asked for a new statutory proposal, 4731.991, patient notification of licensee probation. This is directed at providing valuable information to patients about licensees who've been placed on probation by the medical board for specific types of offenses that involve harm to patient. It's sort of the rounds out the legislative package in that it includes a really direct, tangible way that we're protecting the public by giving them this additional information. This idea came from an FSMB webinar in which a similar statute from California was discussed. So much of the language in this statute is based off of the California language. It's applying to sexual misconduct, drug or alcohol abuse that resulted in patient harm or impairs the ability of the licensee to practice safely, a criminal conviction involving harm to the patient, or inappropriate prescribing resulting in harm to the patient. The licensee would be required to have written disclosure to the patient and obtain a signed copy from the patient confirming that disclosure, and the medical board would be required to provide current information about the probation on its website. So with that, I would open it up to questions, and then we can get back into some of the more, I guess, technical ones or areas where you all have questions. Thank you.
Ms. Montgomery.
I'm trying to understand, and this is a lot to absorb. This has been a heavy board week, and this is a very, I'm trying to understand why we went through the complexity of, I'm probably missing something. We've had for decades the distinction between sexual conduct and sexual contact. We have much legal precedent around it, etc. Why not just increase the penalty on the activity that is already defined, as opposed to going through redefining something called sexual activity? I don't understand the theory.
So I'll give you an explanation. If it doesn't completely make sense, I will call on Angie Canepa to help me out with this. Sexual activity is already defined in the definition section and has been defined in there for quite some time. Sexual activity includes both sexual conduct. I know that. Okay. And then, so the idea is sexual battery includes relationship-based offenses that are occurring when certain, when a doctor is taking care of a patient, or when a teacher is involved with a student. And so what this is basically doing is preserving in the statutory structure that these relationship offenses are, when they're sexual conduct, they're one level of felony, and when they're sexual conduct, they're another level of felony, and they fit more within the way the statute is constructed as relationship-based offenses than they do within sexual imposition, which doesn't have this sort of structure of relationship-based offenses. That was the theory for why fit it in this section.
Is there further discussion? I have a couple thoughts, if I may. First of all, I was just very, very pleased and impressed with the thoughtful, thorough comments that we got. So appreciative to those parties who were kind enough to send in these comments, and so appreciative to Nate of everything you and all the staff have done to put this together. I think it's a great set of proposals. And I did just more specifically want to speak to the 4731.991. So I also had a sense that it was reminiscent of the California language. California has a statute called the Patient's Right to Know Act, and it went into effect on July 1st, 2019. It's the first state in the country to adopt language of this nature. And so, speaking for myself, I really feel like the medical board should embrace that piece of the legislation. I think that it's really the culmination of all the work we've ever done since the governor first proposed the Strauss Working Group. And I think Nate put it really well. It's very tangible. You know, it's a tangible piece of proposed legislation for the public, especially to perceive that we are doing our best in our efforts to protect them. I think it's arguably very impactful, really as much or more than anything we've done so far. I think that it demonstrates to the public that we've responded to the Strauss matter in a serious way. So I just wanted to share my thoughts with you about that. Thanks. Is there further discussion? Mr. Jacqueline.
Just to follow up on this with the California legislation, has there been any unintended consequences as a result of it? For example, now there's more of a push as to what goes in the order. I mean, if we ever heard any downside on it, I guess is my question. I know we can see the upside, right? I'm just wondering, is there unintended consequences there?
Mr. Jacqueline, I'm not aware of unintended consequences. I think probably the history on this is as Dr. Schottenstein says, pretty recent. So, but certainly something that we can, look into more and contact California and get some more information from them. That's something that I'd be happy to do.
Yeah, if you wouldn't mind, just the lessons learned. I'd hate for us to do this and then find out that they've got something that they didn't expect, and then we're sitting with the same thing. Okay, great. And the second question I have is, it looks like the language here, now we're holding healthcare facilities accountable if they don't report. Is that correct, or have I misread this? Or have we done anything in that regard? Remember, that was the whole issue. There's no hooks in the healthcare facilities like hospitals and whatever. And now it looks like, at least if I'm reading this correctly, it looks like there's a hook. Is that correct, or am I misreading this?
I do not believe that we changed the legislation from where it previously was in that regard. I think that the idea that was discussed in July was, we have had situations where a medical director of a facility, we had information that person withheld of failing to report, and so that would be a situation where you would still be talking about the licensee. We have not changed our jurisdiction to discipline beyond licensees.
I do think we did find, and I had not been previously aware, but in 4731.99, there is a criminal component to 224. I'll have to pull it up and look at it, but I think that was something that we hadn't been aware of when we talked in July. That is there. So I think that does. I think that is helpful.
Okay, so there is, Kim, a component then?
There is. So let me pull it up and send.
Right.
And
I mean, that was a big, loophole there. No one wanted to come forward. No one's taking responsibility. The healthcare facilities weren't held accountable. And I thought that we discussed. I know there was a big back and forth. Did we have jurisdiction? Can we get them if we're going statutory? I think one of the comments was, well, why don't we put it out there and let the hospitals push back on it and explain it, as opposed to letting it go.
Right. So 4731.99E, which is the penalty section for the medical board, states whoever violates divisions A, B, C, or D of section 224 is guilty of a minor misdemeanor on a first offense and a misdemeanor of the 4th degree on each subsequent offense, except that an individual guilty of a subsequent offense shall not be subject to imprisonment, but to a fine alone of up to $1,000 for each offense.
Okay.
So just to clarify, that's one of the penalty section that's been revised to just differentiate specifically whoever violates A2 or B3, that would just be a misdemeanor of the 4th degree to make it consistent with 2921.22. But I would say the language in 4731.224 itself has not been changed since our July meeting but under A2, there certainly is, within 30 days of the commencement of an investigation, a healthcare facility shall report to the state medical board criminal conduct or sexual misconduct. That was in your draft in July and continues in this draft unchanged.
Okay, and that's the divisions I was looking at. Okay, perfect. All right, thank you. That's all I have.
Dr. Rothermel.
This is off the specific issue for the medical board because I realize that they're not in our jurisdiction, but just a comment that it always concerns me that nurse practitioners who are under the jurisdiction of the nursing board, but who are providing primary care as physicians and PAs are, we certainly would like them to have the same rules or that physicians and PAs have. And I've always felt that they should be under the auspices of the medical board for the type of practice that they're doing. But I just wondered if there is any coordination with that board as we're looking to do this.
Thank you for that question, Dr. Rothermel. I think it's a great question. I will say Kelly Heil from the Butler County Prosecutor's Office brought up just this issue about the idea of could you expand it to other medical professionals, including nurses. A nurse practitioner would be a good example. And she talked about several more. The way we've structured the legislation to include a definition section for a licensed medical professional, it lends itself nicely to us reaching out when we have this legislation circulated to potentially taking on additional partners with this. I think at this point, we wanted to be humble in our approach to the legislation and not include people without more extensive consultation. But that is certainly something that is an option that we can pursue in terms of collaboration and partnerships in that regard.
Thank you.
Can I
Thank you.
just add just to add to Dr. Rothermel's point, I have heard from a few executive directors asking where we are with our legislation. And I think there is interest in reviewing some of what we're doing. So they've actually reached out to us. I don't think we've heard from the nursing board yet, but certainly I think that's a conversation we'll have and encourage with them to join in that definition. But we'll be shopping all of the healthcare boards with this.
Thank you so much, Ms. Montgomery.
First of all, congratulations on the work. This is a lot of work, and I'm always concerned that when you undertake an enormous change, the outreach is really critical because this is, you're making some substantial changes, and obviously you're reaching out, and I do think it's really critical to get to these other licensing boards. But if you look at 2907-17, can I ask you, this is if under certain circumstances, what the court must do, and then what then the 18, what the prosecutor should do. I will tell you, I was a prosecutor for many years, and I didn't know. Of course, we didn't get that many of these, and I don't know that we ever had one, but I was not aware of this. And I am afraid that if you say, I am much more comfortable that on notice of indictment and notice of conviction, that you require the court as part of it, because then you can plug in the clerks of courts who are excellent in doing all of this kind of thing to get us notification. I think if you rely in 18 to have the prosecutor do it, it's going to be very spotty. And not that you could do that too, but it seems, unless I'm missing something, I would much rather have the court responsible for indictment notice and conviction notice than just a prosecutor. And unless I missed something, you don't have that. And I can just tell you in practice, I fear that you're not going to get that kind of referral from prosecutors.
Ms. Montgomery, I very much appreciate that comment and can identify with it as having been a former assistant prosecutor. You know, I don't believe that I recall all of these statutes from my days doing that as well. I do think that we are starting to forge some really valuable partnerships with OPAA. The fact that the Franklin County Prosecutor's Office is well represented on the Strauss Working Group. The fact that we've got input from Butler, I believe.
I'm not worried about I'm worrying about the Adams County and the
right.
Meigs County and the River County. There's counties where, you know, you've got part-time prosecutors and they're under the gun and they're understaffed and that's the only thing. That's the only reason I'm saying I would much rather do a belts and suspenders than rely solely on the prosecutor. And I love the prosecutors and I have great regard for them. And I think OPAA will do a good job. But many of these folks aren't going to be, the assistants and the prosecutors aren't going to be be at these trainings. And I just think I think you should embed it where you've got more stability and more staff. Just a person.
I appreciate that. One statute does have the court notification, but we can certainly look into the court notifications related to the indictment too. You know, how feasible that lift is for particularly that 2929.42 with all the different offenses and all the different licensing boards. That's something we'd have to look into by talking to the appropriate parties. But I very much appreciate the comment. I think it's, you know, it rings true for sure. So we'll have to navigate that and hopefully make some changes that could improve it. Thank you.
Thank you.
Thank you. Further discussion? Okay, I would just like to thank everybody so much for their work regarding this matter. And so Stephanie, if you'd be so kind, are you inclined to do a sexual misconduct historical case review with us?
Sure. Before we move off the legislation, I'd just like to throw this out. I know we are winding down our days of this committee based on kind of completing so many of the working group tasks. I also know this was a really heavy board meeting and we threw a lot of material at you. What I would propose is that if you spend some more time with the legislation, we'll give you all a few more weeks to really digest it. We can set up some meetings with you as individuals if you have further questions or, you know, if you have further feedback for us. If there are really big substantive changes, then of course we could call the committee back together on this. But I certainly don't want to cut off anybody's opportunity to comment based on how dense this material was. So take your time with it. We'll probably just double check with you individually before we start shopping it, and just let us know if you have any further concerns. And if there are big substantive changes, then we'll bring it back at that time.
And if I may, I would all thank you so much.
Sure. All right, absolutely. Okay, I'm finding my notes here. Sorry, so much paper, so little time. Okay. Share this with you.
Oh, awesome.
Okay. All right. Everybody can see my screen okay?
Mhm.
Okay. So we thought it was timely, given that all of the external review of the historical case has been completed. So all 1,260 something licensees have been reviewed. That we just share a basic, just kind of a high level report out on some of the things that we're finding. What I would say is that I don't consider any of the data final until we complete our very last internal review. We've had a chance to go through all of the data, cross every I, or dot every I, cross every T. This is a snapshot of the data that we have now that the external review has been completed. There might be some cleanup of that data as we go through the files. So the first slide that I have for you shows how the complaints broke down over time in 5-year increments in single versus multiple complaints, right? So I think that one of the questions that we've had or maybe concerns is, do we have people who have a vast amount of offenses who have just sort of gone through time without having action taken? And so what we note is that not really, right? We have some people who have multiple complaints, but the vast majority of complaints against licensees were individual complaints, right? So between 1994 and 1999, 178 were single complaints and 45 were multiple. We did break it down by a multi-year span, and we had 114 licensees who had multiple complaints over 5-year spans. This is sort of, the data is what it is. It's a sort of random breakdown of how to look at this, but overall we thought, just kind of breaking it into time chunks to see how many people had the multiple complaints was interesting. I would call it good to know information, not need to know information. This I think is a little more. Oh, I'm sorry. Do you have any questions on the first slide?
It's just concerning when you look at the 114 that had the number of people that had multi complaints over years. Is that the way you're describing it?
Yes. So let's say for example, between 2015 and 2019, we had 25 licensees with multiple complaints.
They could be sequential or multiple complaints in a limited period of time, or multiple complaints. Last year he did X, 2 years ago he did X, 3 years ago he did Y, this year he did Z. Or are we talking about many complaints all at one time?
So it's over a multi-year time. So we could have had a licensee who had one complaint in 2015 and one complaint in 2019, or they could have had 3 complaints in 2019. And if they span that 5-year time frame, that's the 114, 96 and one complaint in 2016.
Stephanie?
Yes, Dr. Bechtel.
Yes. I would say probably in most situations, the secretary and supervising member and the investigators would be aware of these multiple charges as they accumulate over time. Is that correct?
Yes. So that's our assumption, is that, and hopefully that was practiced, that when being presented, that the secretary and supervising member did know of the multiple complaints. I think we know from our historical case review that that's something we can't go back in time to sit in on those rounds to hear how those rounds went, particularly from this 2000 to 2009 era. Dr. Bechtel? I'm sorry, Dr. Feibel.
Prior to, and thank you for calling me Dr. Bechtel, by the way, I'm flattered. On consent agreements in the future, will we be able to know that someone has multiple complaints, even if only one has been investigated. I don't know how that would work. I don't know if that's even practical, if that would happen. But that's certainly information we would like. If we're doing consent agreements, that's the kind of information we want, apropos of discussions at our retreat yesterday. So.
Yeah, I think that's a good point, and I think that's something that we want to look at is how can we bring those things forward, making sure that licensees have the protections they need, but also making sure that you all have the information you need to have to make the decisions you need to make. Right, as fiduciaries, I think that's important. Yeah, Bob.
Yeah, Stephanie, just a clarification. When we say complaints, are we talking about complaints that are substantiated or just complaints that are made?
So these are all complaints. So our next slide, actually, if we're ready to move on, is
Okay.
Are those complaints that we took action on versus those that we did not. And we don't have this broken down by multiple complaints, but over time, you can see this is interestingly consistent, I think, with the numbers of that we have taken action on. So in 5-year chunks, we have the orange are those actions that had formal action, or those complaints that had formal action. This is not, so in the blue, we might have caution letters. We might have interoffice conferences. Those are not counted as formal action. But there are certainly, I know in the historical case review, there are certainly caution letters, particularly I think with respect to robing or I guess disrobing, and some of the sexual complaints that I would say are more characterized by is unprofessional conduct, but maybe labeled as sexual misconduct when they came in the door. I know Dr. Rothermel and Dr. Safran have been looking a lot at some of these in their rounds. You all feel free to jump in and opine if I'm off base on that. But I would say a lot of those that receive caution letters are more of the unprofessional conduct type.
Thank you.
Any questions on that one? Okay. All right. So next we have, and I think this is the data that is of. This is the need to know information, right? This is what we've all been really curious about. How is this breakdown from the reviewers? What are we looking at with what they recommended? And so you can see that again, we broke this into 5-year chunks just because it's easier to digest. I think that the vast majority are recommending no further action needed, that the close was appropriate. So that was 80% of the complaints. The external reviewer is saying the close was appropriate straight out. We have about a 9.5% total, where the reviewer is saying, you can try to reopen it, but it's probably going to be really difficult. And I would say they were cautious about using that. So I think that where we saw them say it would be difficult to reopen, we absolutely concurred. Let's see if I can, the orange, the darker orange. So if you're looking in 1994 to 1999, the bar that is the number 4, that is our category of reopen. And you can see over time, we have about 6.5% as were recommended to reopen. We had now within that reopen, there may also be duties to report and law enforcement notifications. So in that 6%, we might have multiple things that we need to look at. For only duties to report, we had about 3.6% that needed to be reopened. So, not a huge number. And then our notification to law enforcement is negligible. We noted we had been notifying law enforcement throughout where necessary. So a lot of data to digest, but I think overall this gives a good breakdown of where things stand. And I'll take it just a second again to remind folks of what the next steps look like for this data set, where we're looking at the recommended reopen, or the recommended reopen may be difficult. When all of these external reviews come back into us, even those marked no action needed are still getting a second look from us internally. We're still doing some basic checks on these licensees. We have found a few things where we have been looking at different pieces or older complaints, or and open new complaints based on that. It's a very small number, but I think it's been worth our while to take a look at the licensees. We then, for those that we are that have been recommended to reopen, now we're really getting into that data of why is the reviewer saying recommend to reopen, and can we? We're running into situations where a victim may not be willing to speak with us. A victim may have reached a settlement with the licensee and is unable to speak to us based on that settlement, that legal settlement. The victim may be deceased. And so we are running into some challenges on some of the reopen recommends. Some of them were reopened because you were missing data, and we actually found the data here in the office, right? So we found the follow-up report of investigation, or the follow-up law enforcement notification here in the office on various systems. Some of this data is really old. So some of those, and again, that's why I say I don't consider the data complete until we've completed that internal review. But we definitely have seen some of those situations where where they say reopen, we won't be able to go forward. For others, then we'll be pursuing those just like we would any other investigation and enforcement activity. And those will just be worked, obviously with a sense of urgency because of the timing, but in a normal way that we conduct investigations and enforcement today. We have a great internal team working on this. Looking at this data here, I can say, I'm extremely grateful. One of our investigator supervisors, Sean McCafferty, is really leading the effort in this, in coordinating a lot of the activity. There's a lot of administrative work when we're talking about 1,200 licensees being reviewed. And so, our internal team has been really spot on in looking at this stuff and staying focused. And what we thought would take multiple years, I think, we'll be nearing completion of even the internal review by the end of this calendar year, and which just then frees us up to do more of the day-to-day work, the current day-to-day work. Any questions about this?
First of all, this is just remarkable, the work that the staff has done. Just remarkable, both in the sexual misconduct statute evaluation and this. Just remarkable. Query is so congratulations to all of you. I thought this lift would have taken much longer just because of our systems, if nothing else. Question is, for the cases where we find there's smoke and we want to reopen it, and we think that we have something, for the cases where it may be difficult, but we can't reopen, or we have some evidentiary concerns, etc. Were your comments so we have a doc, we have complaints, we can't prove it for various reasons, they're old, blah, blah, blah. Now the doc is still practicing. Do we have any way to keep an eye on him, flag our system so that if a complaint comes in, we have a focus on that? Again, I don't talking about a blacklist or anything, but for cases where we think there's probable cause, but we just couldn't make it for various reasons. If a complaint comes in now, do we flag it? Do we have any way of flagging it? So we said, wait a minute, we looked at this gentleman before, we could, or this gal before, and we couldn't. but we had concerns, but we couldn't make anything out of it.
Yeah, I mean, I think that's a great question. It's the kind of stuff that keeps me up at night. So I think two answers to that question. First, this has been a tremendous learning opportunity for all of us as a board, as internal staff, working with our AAGs. I think we've all learned a lot. And I think that we would be doing a huge disservice to ourselves if we didn't at the end of this lift say, here's our final report on this, and here's what we've learned, and here's what we need to change going forward. We took something away from this to change, right? And I think one of those things is figuring out how we keep better track of, goes to Bob's question earlier, where there's smoke, there's fire, with looking at some of these folks. So that's one piece of that. I think we need to really figure out a better way of doing that. That being said, we do now, because these files have been so well organized because of this project, all of these complaints are specially noted with a different nomenclature in our system. So say, for example, a doctor receives we close this sexual misconduct complaint that could have been, I don't know, a combination of a 1997, 1998, and 2005 case. They now have in their complaint history a sexual misconduct file. So every time that licensee gets touched going forward, even if we found nothing, right? Doctors have unfounded complaints in the system, but they do have that special file now in the system that should certainly raise red flags that if something comes in the future. And I'll share with you, that's already happened. And so not for ones that we had already closed, but for ones that already had something opened under that SM nomenclature. So I think the way the files are structured, I think that will help. I think we can do more to make sure that we're staying on top of where there's smoke, there's fire.
Thank you.
Thank you. I just want to point out we're coming up on the 9:30 policy, but I'm so glad for final thoughts. Dr. Feibel?
Yeah, just one quick clarification. So you guys said there 2 were reported to law enforcement. Is that of the ones that were closed previously and now have been referred to law enforcement?
So what that 2 is, I was using the example, let's say in the multi-year time span where you can see that the last bar, the reviewers have recommended that we notify law enforcement on 2 of those multi-year complaints. So again, that number, like let's say, for example, 1994 to 1999, of all of the cases in that time span that were reviewed, 5 of them, the reviewer said, you should have notified law enforcement and you didn't. And so now we need to go back and notify law enforcement for whatever that's worth during this time period. So that's what that number means. And it is a very small amount. Like between 2000 and 2004, we had none where we failed to notify law enforcement. Does that make sense?
Yeah, although I will tell you, it is concerning because I think 1 is too many and a failure ultimately of the system. And it is part of what worries me all along when I keep harping on it, but when we're doing sites and things like that, and settlement agreements and things of the nature. So it's just something we need to keep an eye on. 1 of those is too many in my book.
Agreed. And I do not want to seem cavalier at all. Frankly, I think my fear was that we would have more. And so it is absolutely a big concern and something that was a big focus within the working group itself. We have since, at the very beginning of this, not long after I started, we actually redid our law enforcement notification protocol, and we did that with staff involvement, investigators, legal, enforcement. We're all involved in that notification, that law enforcement notification. And I think it's definitely at the forefront of everyone's mind. It just needs to be embedded in our culture. And I think, what I would say is over time, I think it probably has been more than we feared it wasn't, but you're absolutely right. 1 is too many.
Thank you also very kindly for your thoughtful comments, and for, to the staff for all of your hard work. I'll entertain a motion to adjourn.
Move.
Second.
Mr. Dupont, Ms. Montgomery, thank you so much. All in favor, please. Aye.
Aye.
See you all soon. Thanks again.
Thank you.
Dr. Schottenstein,
Yes.
this is Kim.